Today I thought I would share some ideas regarding what do you do when a loved one dies. That involves a variety of things, but before we even get there, we should raise the question as to how you even prepare for that day. So you're doing planning, because that makes that day and the days that follow much less stressful if you've done some planning in advance. That planning can be that can involve the review of beneficiary designations for retirement plans that you may have at work, such as a 401k plan or a profit sharing plan, a 457 plan. All of these plans are called qualified plans. They're employer plans, but you also have individual plans such as an individual retirement plan or a Roth IRA. They all have beneficiary designations, so review them and discuss it with your advisors as to how to have both the primary and the secondary beneficiary designation for those types of retirement vehicles. You also should review life insurance and make sure your life insurance beneficiary designations are properly consistent with your estate planning goals and objectives. So doing planning in advance can make things infinitely easier. They can not only mitigate taxation, both in terms of capital gains and income tax that may be due, but they can also, in doing planning with various documents and beneficiary designation, allow for you to avoid probate. And that is both time, cost, and emotion that your loved ones as survivors have to deal with. So one less burden that you can put on their shoulders upon death if you've done some advanced planning. So I'm talking to the survivors right now. These are those who have lost a loved one. So what do you do? There's some administrative things that I'm going to go over, and then I'll go over some post-mortem planning, things that actually can help you in moving forward with an estate that you may inherit. But let's start with a spouse, for example, that loses his or her husband or wife. If there's a surviving spouse, here are some of the things that need to be attended to. The first is normally there's a funeral home involved, and speak to them about getting death certificates. There's no absolute rule of thumb. It depends how many assets are governed and require a titling change, but often we say 5 to 10 death certificates, unless it's a more complicated estate, and then you may get 15 or 20. They're not that costly. It makes for an easy transition because many institutions will require a separate death certificate in order to follow with your instructions or the instructions of the documents. So that would be the first step. There's also the communication with Social Security. If Social Security is being received, it has to be stopped. So you want to advise the Social Security Administration that someone has died. Otherwise, there could be back payments that are owed to the Social Security Administration because you're receiving directly, often as it's done, electronic transfers may continue to go into an account that no longer is entitled to that money. Know also, if you are a surviving spouse and the loved one that has died had a Social Security income that was greater than yours, that you're entitled to the greater of the two. So what you need to do is contact Social Security to then have yours stopped and have your loved ones switched over to you, so you always maintain the higher Social Security amount. You're not, unfortunately, entitled to both. So you're going to have one Social Security payment upon the death of your loved one. So, death certificates, Social Security, going over your life insurance contracts, advising insurance companies of this. When your death certificates arrive, you can submit an insurance application to get those proceeds. If you don't have any documents, such as a will, such as a trust, then there may be some assets that need to be probated. If there's a house that was jointly held between spouse and the spouse is no longer alive, then the way to handle that is in one of two ways. Since there's only one person's name on the deed, you may want to consider having that home retitled to a trust. The reason for that is that it will avoid probate. If you have just one person's name on the trust, it's going to be subjected to a probate administration when you die. So that would be one choice. Another choice would be to add people to the deed, such as your children. Normally we don't advise that. And the reason we don't advise that is because, let me use this hypothetical. Your husband dies, but you have 3 children. If you had 3 children as joint owners of your property, your home, that sounds like a real elegant way to handle it, because by operation of law, if you die, the kids will share in the house. The problem is they also share in the liability exposure, so that if one of them gets in a car accident and there's a judgment against them, they can attach your house as part of a settlement. That's not normally good planning. So we like to limit the liability exposure that you have to that which is only incumbent upon you, not multiply because you have 4 other people that could get into a litigious situation because of a car accident and whatever it might be, and then put your house at risk of going away because it was attached in a lawsuit. So we've talked about Social Security. We've talked about looking at retirement plans. We talked about life insurance. We've talked about being able to change joint property when it's appropriate. And now I want to just mention a few other things that really need to be considered. If there were investment accounts in the person's name that just died, the beneficiaries have a right to take those investments and create a new cost basis. Why is this important? If you had investments that had been growing over a number of years, there could be significant capital gains that if that investment were to be sold would be triggered. So if you have a $10,000 investment, it grows to $100,000, there's $90,000 of exposure for capital gains. What happens upon death is that your loved one is going to enjoy a step up in basis for your benefit, so that based on the date of death, the new step up basis is $100,000. So make sure to talk to the investment advisor and ensure that you enjoy that step up in basis. It's not done automatically. You have to pursue it. You have to insist upon it. And then you, at the date of death, have an entirely new game. So you can, at that time, for example, liquidate assets that otherwise you might be really reluctant to do because you'd have to pay a tax. Now, needless to say, you'd have to scrutinize whether selling an asset is a good idea or not. But the fact is, it gives you all sorts of options, knowing that you're not tied to that capital gain tax that you would have otherwise had to pay. So looking at step up in basis, being able to plan for the future, being able to consider how the life insurance proceeds flow, being able to retitle assets in terms of who the ownership is, and limiting your house to either a trust fund death designation or a trust funding will enable you to mitigate any additional risk if you put your kids on the deed. So you have, as I said, starting out, you have advanced planning that can be done before death, and then you do post-mortem planning. And I think in the end, I'll limit my discussion to these areas. There are many others that can be identified, but this would be a good beginning in terms of giving you a frame of reference for what one does, both in preparing for death of a loved one, and then the kind of things that are useful to know need to be exercised and followed through with when that unfortunate event actually occurs. Hope this helped. Thanks.